Excuse me. Okay, this is the recent complaint I filed with the ARDC. I sent it via email, and you see it was September 9th, 2020. There's the lawyer's names. Okay. Now this is a form. I couldn't put the name of the law business because this was in '79 that these people are either dead, retired. Okay. Have you previously contacted the ARDC regarding this matter? I forgot to put no, but no, I didn't. Not this matter. But in another case, did you employ the lawyer persons you're claiming about? Yes, I forgot to mark that. Okay. So down here is where you're going to put, copy and paste all your rules, preamble. But like I said, you need a good opening statement. And it says, please explain your complaint, include important dates and names of witnesses and others involved. Use additional pages if necessary. Attach copies of documents that support your complaint, such as fee agreements, receipts, checks, letters, and court papers. Now, the way I worded this, all you need are the rules. Depends on your opening and closing statement. This complaint is based on due process guaranteed through the 5th and 14th Amendment of the United States Constitution, or the lack of in the above-mentioned case. What was unknown to me was the legal responsibilities of the court and officers of the court. This is why I'm filing this complaint. I will cite the preamble, the rules of professional conduct, and state whether or not court and counselors were in compliance. I doubt it need be said, noncompliance with the preamble and the rules of professional conduct is a violation of my constitutional right to due process. Any violation is ineffective assistance counsel. Any violation is ineffective assistance counsel, which clearly shows the ineffectiveness of the court for not requiring counsels of either party to follow their legal responsibilities as prescribed by the preamble and the rules of professional conduct. From this point on, I will cite the preamble and the rules of professional conduct, or whether or not there was a failure to apply. Supreme Court of Illinois. Okay. There we go. So I just copied the preamble. See, and I just put everything behind it. Failure to comply. A lawyer, as a member of the legal profession, is a representative of clients and officer of the legal system and public citizen having special responsibilities for the quality of justice. Failure to comply. As a representative of clients, a lawyer performs various functions. As advisor, lawyers provides the client an informed understanding of the client's legal rights and obligations and explains their practical implications. As an advocate, for a lawyer zealously asserts the client's position under the rules and the advisory system. As a negotiator, a lawyer seeks a result advantageous to the client, but consistent with the requirements of honest dealings with others. As an evaluator, a lawyer acts by examining a client's legal affairs and reporting them to the client or to others. Failure to comply. In addition to these representational functions, a lawyer may serve as a third-party, neutral, non-representational role, helping parties to resolve a dispute or matter. Some of these rules apply directly to lawyers who are or have served as third-party neutrals. In addition, these rules that apply to lawyers who are not active in the practice of law or practicing lawyers, even when they are acting in a non-professional capacity. For example, a lawyer who commits fraud in the conduct of business is subject to discipline for engaging in conduct involving dishonesty, fraud, deceit, or misrepresentation. See Rule 8.4, failure to comply. In all professional functions, a lawyer should be competent, prompt, and diligent. A lawyer should maintain communication with the client concerning representation. A lawyer should keep in confidence information relating to the representation of the client as far as disclosure is required and permitted by the rules of professional conduct or other law. Failure to comply. A lawyer's conduct should conform with the requirements of law, both professional service to clients and lawyers' business and personal affairs. A lawyer should use the law's procedure only for legitimate purposes and not to harass or intimidate others. A lawyer should demonstrate the respect for the legal system and for those who serve it, including judges, other lawyers, and public officials. While it is a lawyer's duty, when necessary, to challenge the rectitude of official action, it is also the lawyer's duty to uphold legal process. Failure to comply. As a citizen, as a public citizen, a lawyer should seek improvement of the law. Access to the legal system, the administration of justice, the quality of service rendered by legal profession. As a member of the learned profession, a lawyer should cultivate knowledge of law beyond its use for clients, employ that knowledge and reform the law, and work to strengthen legal education. In addition, a lawyer should further the public's understanding of confidence in the value of law and the justice system, because legal institutions in a constitutional democracy depend on popular participation support to maintain their authority. Failure to comply. It is also a responsibility of those licensed as officers of the court to use their training, experience, and skills to provide services to the public interest for which compensation may not be available. It is the responsibility of those who manage law firms to create an environment that is hospitable to the rendering of reasonable amount of uncompensated service laws practicing in that firm. Service in the public interest may take many forms. These include, but not limited to, pro bono representation or persons unable to pay for legal fees and assistance in the organized bar's efforts at law reform. An individual. Okay. Sorry. A lawyer should conform to requirements of law, both professional service clients and the lawyer's business personal affairs. A lawyer should use law's procedure only for legitimate purposes and not to harass and intimidate others. A lawyer should demonstrate respect for the legal system for those who serve it, including judges, other lawyers, and public officials, which it's a lawyer's duty, when necessary, to challenge the rectitude of official action. It's also a lawyer's duty to uphold the legal process. 6. As a public citizen, a lawyer should seek improvement of the law, access to the legal system, the administration of justice, and the quality of service rendered by legal profession. As a member of the learned profession, a lawyer should cultivate knowledge of law beyond its use of clients, employ that knowledge and reform the law, and work to strengthen legal education. In addition, lawyers should further the public's understanding of the confidence of these rules, laws, and justice system, because legal institutions in a constitutional democracy demand popular participation support to maintain their authority. Failure to comply. 6A. It is the responsibility of those licensed as officers of the court to use their training, experience, and skills to provide services in the public interest, which, I already read that. Compensation may be, that's for pro bono, or basically people that can't afford a lawyer. But I copy and paste that. Failure to comply. 6B. The absence from the Illinois rules of counterpart to the ABA Model Rule 6.1 regarding pro bono public service should not be interpreted as limiting the responsibility of lawyers to render uncompensated service in the public interest. Rather, the rationale is the responsibility as appropriate for disciplinary rules, because it is not possible to articulate an appropriate disciplinary standard regarding pro bono. Failure to comply. Many of the lawyer's professional responsibilities are prescribed in the rules of professional conduct, as well as substantive, and procedural law. However, a lawyer is guided by personal conscience and arbitration of professional peers. A lawyer should strive to attain the highest level of skill to improve the law, the legal profession, and exemplify the legal profession's ideals of public service. Failure to comply. A lawyer's responsibility as a representative of clients, an officer of the legal system, and the public's citizens are usually harmonious. Thus, when opposing party is well represented, a lawyer can be zealous advocate on behalf of a client and at the same time assume that justice is being done. So also, a lawyer can be sure that preserving clients' confidence uh, ordinarily serves the public interest, because people are more likely to seek legal advice, thereby heed the legal obligations when they know that communications will be private. Failure to comply. In the nature of law practices, however, conflicting responsibilities are encountered. Virtually all different ethical problems arise from the conflict between the lawyer's responsibilities to clients, to the legal system, the lawyer's own interest in remaining an ethical person while earning a satisfactory living. The rules of professional conduct often prescribe terms for resolving such conflicts. Within the framework of these rules, however, many difficult issues of professional discretion can arise. Such issues must be resolved through the exercise of sensitive professional and moral judgment guided by the basic principles underlying the rules. These principles include a lawyer's obligation zealously to protect and pursue a client's legitimate interests within the bounds of the law while maintaining professional, courteous, civil attitude towards all persons involved in the legal system. Failure to comply. The legal profession is largely self-governing, although the professions also have been granted powers to self-government. The legal profession is unique in the respect because of close relationship between the profession, process of government, and law enforcement. This connection is manifested in the fact that the ultimate authority over legal profession is vested largely in the courts. Failure to comply. To the extent that lawyers meet obligations of their professional calling, the occasion for government regulation is obviated. Self-regulation also helps maintain the legal profession's independence from government domination. An independent legal profession is an important force in preserving government under law, for abuse of legal authority is more readily challenged by a profession whose members are not dependent on government for the right to practice. Failure to comply. Legal profession's relative autonomy carries it with special responsibilities of self-government. The profession has a responsibility to assure that the regulations are conceived in the public interest and not in furtherance of a patriarchal or self-interest concerns of the bar. Every lawyer is responsible for observance of the rules of professional conduct. A lawyer should also aid in securing their observance by other lawyers. Neglect of these responsibilities compromises the independence of the profession and the public interest which it serves. Failure to comply. Lawyers play a vital role in the preservation of society. The fulfillment of this role requires the understanding by lawyers of their relationship of our legal system. The rules of professional conduct, when properly applied, serve to define that relationship. Failure to comply. Scope. The rules of professional conduct are rules of reason. They should be interpreted with reference to the purposes of legal representation and law itself. Some of these rules are imperative, cast in the terms of shall or shall not. These define the proper conduct and purposes for professional discipline. Others generally cast in the term are permissive, define areas under the rules which a lawyer has discretion to exercise professional judgment. No disciplinary action can be taken when a lawyer chooses not to act or acts within the bounds of such discretion. Other rules define the nature of relationships between lawyers and others. The rules are thus obligatory and disciplinary and partly constitutive of and descriptive, and they define the lawyer's professional role. Many of the comments use the term should. Comments in the preamble and the scope do not add obligation to the rules, but provide guidance for practicing in compliance with the rules. The rules propose a large legal extent shaping the lawyer's role. That context includes court rules and status relating to matters of licenses, laws defining specific obligations of the lawyer, and substantive and procedural law in general. The comments are sometimes used to alert lawyers to their responsibilities under such other law. Compliance with the rules, as with all law in an open society, depends primarily upon understanding and voluntary compliance, secondarily upon reinforcement by peers and public opinion, and finally, when necessary, upon enforcement through disciplinary proceedings. These rules do not, however, exhaust the moral and ethical considerations that should inform a lawyer, for no worthwhile human activity can be completely defined by legal rules. Rules simply provide a framework for the ethical practice of law. Furthermore, for the purpose of determining a lawyer's authority and responsibility, principles of substantive law external to these rules determine whether a client-lawyer relationship exists. Most of these duties following the client-lawyer relationship attach only after the client has requested a lawyer to render legal services and the lawyer has agreed to do so. But there are some duties, such as the confidentiality under Rule 1.6, that attach when a lawyer agrees to consider whether a client-lawyer relationship has been established. See Rule 1.18, whether the client relationship exists for any specific purpose can depend on the circumstances and may be a question of fact. 18. Under various legal provisions, including constitutional, statutory, and common law, the responsibilities of government lawyers may include authority concerning legal matters that ordinarily reposes in a client and private client-lawyer relationships. For example, a lawyer for a government agency may have the authority on behalf of government to decide upon a settlement and whether they appeal an adverse judgment. Such authority in various respects is generally vested in the Attorney General and State's Attorney in state government and their federal counterparts, and the same way may be true for other government law offices. Lawyers under the supervision of these offices may be authorized to represent several government agencies, including intergovernment legal agencies, in circumstances where a private lawyer could not represent multiple private clients. These rules do not abrogate any such authority. 19. Failure to comply with an obligation or prohibition imposed by a rule of basis of invoking disciplinary process. See why I keep saying failure to comply? So let me read that again. Let me reiterate that. 19. Failure to comply with an obligation or prohibition imposed by the rules is a basis for invoking disciplinary process. These rules presuppose that disciplinary assessment of a lawyer's conduct will be made on the basis of fact and circumstances as they existed at the time the conduct in question, the recognition of the fact that the lawyer often has to act under certain or incomplete evidence or the situation. Moreover, the rules propose that whether or not discipline should be imposed for a violation, and the severity of a sanction depend on the circumstance, such as willfulness, seriousness of the violation, extenuating factors, and whether there have been previous violations. 20. A violation of a rule should not itself give rise to cause of action against the lawyer, nor shall it create any presumption in such case that legal duty has been breached. In addition, violation of rules does not necessarily warrant any other non-disciplinary remedy, such as disqualification of a lawyer in pending litigation. These rules are designed to provide guidance to lawyers to provide a structure for regulating conduct through disciplinary agencies. They are not designed to be a basis for civil liability. Furthermore, the purpose of the rules can be subverted when they are invoked by opposing parties as procedural weapons. The fact that the rule is just a basis for lawyer self-assessment for sanctioning a lawyer under the administration of a disciplinary authority does not imply that an antagonist in collateral proceedings or transactions has standing to seek enforcement of the rules. Nevertheless, since these rules do establish standards of a conduct by a lawyer's violation of rules may be evidence of a breach of the applicable standard of conduct. 21. The comment accompanying each rule explains and illustrates the meaning and purpose of the rule. The preamble and the note on scope and provide general orientation and other instructive and not directive. The comments are intended as guides to interpretation, but the text of each rule is authoritative. Okay. Rule 1.1, competence, failure to comply. A lawyer shall provide competent representation to a client. A lawyer shall provide competent representation to a client. Competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the participation. The court and counselors failed to reveal legal responsibilities and in doing so acted in an incompetent manner. Rule 1.2, scope of representation and allocation of authority between client and lawyer. Failure to comply. Subjects to paragraph C and D, a lawyer shall abide by the client's decision concerning the objectives of representation as required by Rule 1.4, shall consult with the client as to the means by which to be pursued. A lawyer may take such action on behalf of a client and is repeatedly authorized to carry out representation. A lawyer shall abide by a client's decision whether to settle a matter. In a criminal case, the lawyer shall abide by the client's decision after consultation with the lawyer as to a plea to be entered, whether to waive jury trial, or whether the client will testify. A lawyer may limit scope of representation and reasonable under circumstances the client gives informed consent. Okay, I'm going to skip over a lot of this. Like I said earlier, all you got to do is copy the rule, failure to comply, copy and paste everything under that rule. It's a complete definition how this is supposed to work. Okay, like I said, and the client gives informed consent. A lawyer may limit the scope of representation if limitation is reasonable under circumstances and the client gives informed consent. A lawyer shall not counsel a client to engage or assist the client in conduct the lawyer knows is criminal or fraudulent, but a lawyer may discuss the legal consequences of the proposed course of the conduct of the client. Console or assist the client to conduct in conduct expressly permitted by the Illinois law that may violate or conflict with federal or other law, as long as the lawyer advises the client about the federal law or other law, its potential consequences. Diligence. Failure to comply. A lawyer shall act with reasonable diligence and promptness in representing a client. Failure to comply. No professional shortcoming is more widely resented than procrastination. Considering the time involved, professional procrastination prevailed versus diligence. Communication. Failure to comply. There was little or no communication. I was rarely spoken to, even in court. In court, the terminology used was incomprehensible. The language used was unfamiliar to me. Going beyond layman's terms, which refused language phrased simply enough that a layman or common person can understand, was inappropriate, as I am not a learned, educated, seasoned professional of the legal community. If given the financial means, time, and opportunity, it would then be acceptable. But that would require everyone within this nation of laws to become a lawyer just to understand what goes on in courts. That is impossible and won't be happening in the near future. Complicated things to keep the client unaware is not in the public interest and defies the logic of reasonable knowledge and compounds the violations with the right to due process. Might as well speak in Russian, comrade. I don't speak that either. Reasonably informed is a key element. A lawyer shall promptly inform the client of any decision or circumstances with respect to the client's informed consent as defined in Rule 1.0E is required by these rules. Reasonable consult with the client about the means by which the client's objectives are accomplished. Keep the client reasonably informed about the status of the matter. Promptly comply with reasonable requests for information, thus discovery. Promptly comply with reasonable requests for information, discovery. Consult with the client about any relevant limitations of the lawyer's conduct when the lawyer knows that the client expects assistance not permitted by the rules of professional conduct or other law. The lawyer shall explain a matter to the extent reasonably necessary to permit the client to make informed decisions regarding the representation. Reasonable communication between the lawyer and the client is necessary for the client effectively to participate in representation. Okay, communicating with the client if these rules requires that a particular decision about the representation made. If these rules require that a particular decision about the representation be made by a client, paragraph A1 requires that the lawyer promptly consult with and secure the client's consent prior to taking action unless prior discussions with the client have resolved that the action the client wants the lawyer to take. For example, a lawyer who receives from opposing counsel an offer of settlement in a civil controversy or pre-offered plea bargain in a criminal case must promptly inform the client of its substance unless the client has previously indicated that the proposal will be acceptable or unacceptable or has authorized the lawyer to accept or reject the offer. Okay, paragraph requires a lawyer to reasonably consult with the client about the means to be used to accomplish the client's objectives. Okay, I want to keep skipping down, but like I said, everything under that rule I just copied and pasted, and that clearly says right here. You know, there's a whole. Some of this wording in here is of my own, like this part right here. That's me. Okay. So it'd probably be easier if you ask me for a copy of this, and no matter what state you're in, you could add this on your complaint. It says reasonable communication between the lawyer and client is necessary for the client to effectively participate. Okay. Explaining matters. See, all this they didn't do. So this is my complaint. The client must give conformed consent. They didn't tell me nothing. I was 17 at the time. I was studying law, but I did not know these rules existed. Okay, so that's a lot of copy and paste, right? Okay, but hey, it's better than typing it out. My hands don't work that good, and I was teaching myself to type, but my health got really bad, and thank God I got my hands fixed, 2 operations, carpal tunnels. Okay, fees, failure to comply. If any fee is exuberant if not in compliance with the rules of professional conduct. And that's just a copy and paste underneath what it says for fees. And I don't think I need to read that to you. I mean, if you're going to do it, just copy and paste all this crap, put it there, and it'll be good enough. Rule 1.6, confidentiality of information, failure to comply. A lawyer shall not reveal information relating to the representation of a client unless the client gives informed consent. And that's a serious failure to comply, because when I told the lawyer that I was going to file with the ARDC against him, the state's attorney, with the Judicial Inquiry Board, file complaints to get, with Judicial Inquiry Board and the ARDC, he went back and told the judge, and I'm guessing the state's attorney, and they had the sheriffs take me downstairs and beat the life out of me. Okay, so you can copy that and paste it on there. See right here. Thus, a lawyer who knows from information relating to representation of the client or other person is act or is entering discharge. Oh, never mind. That's for environmental purposes. Withdrawal. Lawyer services will be used by a client material. Furthermore, in the course of criminal fraudulent conduct, the lawyer must withdraw. Acting competently to preserve confidentiality, they don't do that. So this is my complaint now. When transmitting communication, the duty of confidentiality continues after the client relationship is terminated. See Rule 1.9C2. The rule, see Rules 1.9C1 for the prohibition against using such information to the disadvantage of former clients. Rule 1.7, conflict of interest, failure to comply. A lack of reasonable knowledge to make an informed decision by any client by the means is conflict of interest. It clearly shows a lack of diligence and communication, and it only shows a means to compound fees by professional procrastination. Okay, that's me right there, this little part right here. Okay, that's me. That's my wording. So, if you want that, let me know. Okay, and here's our comments. And like it said up there, this explains to the lawyer what he's got to do. So if you read that, then you'll know what he's got to do. Failure to comply on all of this. Okay. This part on 10, personal interest conflicts. The lawyer's own interest should not be permitted to have an adverse effect on representation of the client. When lawyers representing different clients, but see, that's all under that one rule, so I just copied and pasted the whole thing to remind the ARDC what they're supposed to know and why they're supposed to be violating the lawyers, state's attorney, the judge. See, even at the bottom it said informed consent. Informed consent requires that each affected client be aware of relevant circumstances and of the material and reasonably foreseeable ways that the conflict could cause adverse effects on the interest of the client. See Rule 1.0E, informed consent. Don't forget, when you copy and paste this, read this stuff, okay? I mean, you can always print out a copy, highlight whatever, and, carry that with you so you don't have to remember it, but at least read it. Rule 1.6, declining or terminating representation, failure to comply. If a lawyer lacks the competence and willingness to abide by legal responsibilities prescribed by the preamble and the rules of professional conduct, should they not decline or terminate representation? And there's a lot of copy and paste underneath it. And it just comes from the rule on the website. So you just copy and paste the rule, failure to comply, copy and paste everything underneath it to show you know what they're supposed to do and to show them that you know that they're not doing what they're supposed to do. Assisting the client upon withdrawal. Even if a lawyer has been unfairly discharged by a client, a lawyer must take all reasonable steps to mitigate the consequences to the client. The lawyer may retain papers as security for a fee only to the extent permitted by law. Rule 2.1, advisor. Failure to comply in representing a client. A lawyer shall exercise independent professional judgment and render candid advice. In rendering advice, a lawyer may refer not only to law, but other considerations as moral, economic, social, political factors that may be relevant to the client's situation. And as you see, I added the comments. The client is entitled to straightforward advice expressing the lawyer's honest assessment. Rule 3.1, meritorious claims and contentions. Failure to comply until the rules are applied, there are no meritorious claims and contentions. A lawyer shall not bring or defend a proceeding or assert or controvert an issue therein unless there is a basis in law and fact in doing so that is not frivolous which includes good faith argument, extension, moderation, reversal of existing law, a lawyer of the defendant in a criminal proceedings or respondent proceedings that could result in incarceration may nevertheless so defend proceedings as to require that every element of the case be established. Every element of the case. Expediting litigation. Failure to comply. Considering the time involved, it's clear expediting litigation was not a priority, nor was it shared with opposing party, nor offered. Disclosing to the client the opposing party disclosure to the client the opposing party is necessary to make an informed decision, and lack of defies the concept of being reasonably informed. As it is necessary, every counselor need to be asked before discovery, but the deed should be implied. Okay, as this is a necessity, every counselor need not be asked for discovery. Okay, so I mean they should be ready before a preliminary hearing, long before you go to trial. Ever notice the constant continuances because they don't have discovery complete? Okay, so we're going to go, okay, where was I? Let me start again. Expediting litigation, failure to comply. Considering the time involved, it's clear expediting litigation was not a priority, nor was it shared with opposing party, nor offered. Disclosed to the client the opposing party is necessary to make informed decision. Lack of defies the concept of being reasonably informed. As it is necessary to every counselor need to be asked, as this is a necessity, every counselor need not be asked for discovery, but the deed should be implied and offered to be said to the client, be fully informed to make a reasonable decision as to what course of action to take. Take that decision lies solely with said client, not the assistance of counsel. I, the client, request full disclosure and a copy of discovery, which I have yet to receive to this date. If it was offered, as well as being told the legal responsibility set forth through the rules of professional conduct, I believe the outcome would have been much different. Those were my words. I just doing little snarky remarks. Candor towards a tribunal. Failure to comply. A lawyer shall not knowingly make false statements of fact or law to a tribunal, or fail to correct false statements of material fact or law previously made to a tribunal by the lawyer. Fail to disclose to the tribunal legal authority and controlling jurisdiction known to the lawyer to be directly adverse to the position of the client and not disclosed by opposing counsel. Offer evidence the lawyer knows to be false. If a lawyer, the lawyer's client, or a witness called by the lawyer has offered material evidence and the lawyer comes to know of its falsity, the lawyer shall take reasonable remedial measures, including, if necessary, disclose to the tribunal. A lawyer may refuse to offer evidence other than the testimony of a defendant in a criminal matter that lawyer reasonably believes to be false. A lawyer who represents a client in an adjudicated proceeding who knows the person intends to is engaging in or engaging in criminal or fraudulent conduct related to proceedings shall make reasonable or remedial measures, including, if necessary, disclose to the tribunal. The duties stated in paragraph A and B continued to the conclusion of the proceedings and apply even if a compliance requires disclosure of information otherwise protected by Rule 1.6. So if they don't give you discovery, this is telling you right, that's a violation. In ex parte proceeding, a lawyer shall inform the tribunal of all materials, known facts to lawyers that will enable the tribunal to make an informed decision whether or not the facts are adverse. All lawyers have a special obligation to protect the tribunal against criminal or fraudulent conduct. Okay, you know that doesn't happen. Disclosure is necessary for the client to make an informed decision, so it's easy to state candor towards the client. Candor toward the client is just as essential as candor towards a tribunal. Was the court in the dark about the client being in the dark? Having access to discovery is vital for a client to make an informed decision. That's me there again, okay? This rule governs governs the conduct of a lawyer who is representing a client in the proceedings of a tribunal. Okay, down here, requires a lawyer to take reasonable remedial measures if a lawyer comes to know that a client who is testifying in a deposition has offered evidence that is false. I've seen that happen quite a few times. The rules are set forth special duties of lawyers as officers of the court to avoid conduct that undermines the integrity of the adjudicative process. A lawyer acting as an advocate in adjudicative proceeding has an obligation to represent the client's case with persuasive force, performance of the duty while maintaining confidence of the client. However, is qualified by the advocate's duty of candor to the tribunal. Okay, what's in here? So I'm going to scroll down because this video is starting to take a little bit. So I'm just going to move on to the next rule. But just know that I copied and pasted the rule and everything underneath. And then moved on to the next rule that they didn't comply with. And mind you, this is commonly done by lawyers and judges. Rule 3.4, fairness to the opposing party and counsel. Failure to comply. Impossible only when counselor is reasonably informed and not the opposing party. You are the opposing party. I forgot which rule it is. It's fairness to the opposing party and counsel. So you are the opposing party. If they're fair to your counsel, but not you, it's a violation. And you know damn well your counsel's not going to give you anything. A lawyer shall not unlawfully obstruct another party's access to evidence or unlawfully alter, destroy, or conceal a document or other material having potential evidentiary value. A lawyer shall not counsel or assist another person to do any such act. Falsify evidence, console, or assist a witness to testify falsely. Hold on. Just grabbing a cigarette here, folks. Okay, just know that all this you're supposed to know. Your lawyer's supposed to know. Seriously, when you go to court, you know, it seems like they don't know this. I mean, you literally have to go to law school to learn this. But this used to be just in books, but now it's on the internet, and I'm sharing what's in my head that I got out of those books, and here it is. I looked it up on the internet. There it is. Okay, Rule 3.5, impartiality and decorum of the tribunal. Failure to comply. The tribunal is the judge and the lawyers, okay? Impartiality and decorum of the tribunal. Failure to comply. A lawyer shall not seek to influence a judge, juror, prospective juror, or other officials by means prohibited by law. Communicate ex parte. Communication is prohibited by law, court order. It's just telling you what. Okay, but you can go over that yourself. Just know that impartiality and decorum of the tribunal, which is the judge and the lawyers participating in the sham that you are an audience to, tells you right here, a lawyer shall not, and they do it anyways. Okay, so just copy and paste it down below the rule and just put failure to comply. You see where I got the term from, right? Trial publicity. Failure to comply. A lawyer who is participating or has participated in investigation, litigation, or matter shall not make an extrajudicial statement the lawyer knows or reasonably should know will be disseminated by the means of public communication or will pose serious and imminent threat to the fairness of an adjudicative proceeding. Notwithstanding paragraph, a lawyer may state, but the trial publicity my lawyer got by informing the judge. I don't know how they did it, but you know, like I said. I was highly prejudiced because, as I said, my judge and the plaintiff, my ex-fiance, I don't know how related, but they have the same last name. My lawyer made it very clear in court. State's attorney, judge, there was actually a couple of states. They looked like they wanted to shoot me on the spot. But why? All the evidence they had to prove I was innocent, they withheld to make me look guilty. Without all that evidence, without the documentation, without discovery of facts is what I'm speaking of. How am I able to prove my innocence? My lawyer definitely wasn't doing it, or my assistant of counsel, my counselor. So just copy and paste that. And trial publicity doesn't have to be just in the media. Trial publicity can be between the judges and lawyers, okay? So my lawyer, and he wasn't my lawyer, that was my mother and my siblings' idea. And somehow or another, they went to court, and I wasn't in there, and they fired my lawyer and brought in this other guy. And he literally threw my case. So, this is, the ARDC should understand this, and so should you. Apparently, most lawyers don't. What the hell they go to school for? So this is my closing statement. Trial publicity will always exist in a bench trial. Trial publicity is to prohibit swaying the opinion of a judge or jury. In the pretrial proceedings, a defendant's history is discussed in detail between the judge and attorneys. Information withheld from a jury for bail, etc. How is that showing impartiality and decorum of the tribunal? That's why I told you people, I strongly advise you to take a jury trial over a bench trial, because there's a lot of trial publicity going on in that court. The state's attorney will bring up anything and everything to prejudice the judge against you. Now, there's no way in hell the judge isn't going to use any of that information, and he or she will come up with a biased decision. So go with a jury. A jury is not allowed any of this information. That's just in my opinion. It's up to you what you do. Oh, that statement is mine there. I added that, okay? That was between the rule and the comments. Well, basically, this is all failure to comply. Special rules of the prosecutor. Failure to comply. The duty of a public prosecutor is to seek justice, not merely to convict. The prosecutor in the criminal case shall. Now, let me reiterate that. I put special rules of prosecutor, failure to comply. The duty of a public prosecutor is to seek justice, not merely to convict. Now, how are they seeking justice when it clearly said in the above-mentioned statements that I made that about discovery? Discovery is what they're going to use, what your lawyer's going to use, and it must be given to you, the client, okay? So just, you really got to think about that. And if they refuse to give it to you, you're never going to be able to prove anything. And that's the whole point. See, they didn't give you crap. They don't give nobody crap. Anything. They won't give you anything. And that's how you lose. And the rules of professional conduct strictly say they cannot keep that from you. Okay, the duty of a public defender is to seek justice, not merely to convict. The prosecutor in a criminal case shall refrain from prosecuting a charge the prosecutor knows is not supported by probable cause. Remember, people, I mentioned a probable cause hearing. When you get arrested, the first shot you get in court, demand a probable cause hearing, and it'll get thrown out that day. You can't get arrested for being loud or flipping or giving a cop the bird, and they will arrest you for, driving while black, walking while black, riding a bike. Well, I'm Mexican. It's the same thing. In my day, when I was growing up, in the 60s, the 70s, even in the 80s, they always said, and I only had to hear it one time, if you ain't black, you're just another effing N-word. So as a Mexican, even if I was Chinese or Japanese or Muslim, Hindu, I would be black. Okay, So, so let's go back to A. Let me reiterate that. Refrain from prosecuting a charge that the prosecutor knows is not supported by probable cause. So you walk in that court the first time, public defender won't ask for it, and certainly your private attorney won't ask for it unless you pay a substantial fee. That's why I said fees. If you remember what I said about fees up there, make reasonable efforts to ensure that the accused have been advised of the right to and the procedure for obtaining counsel and has been given reasonable opportunity to obtain counsel. Let me reiterate that. Make reasonable efforts to ensure that the accused have been advised of the right to and the procedure for obtaining counsel. Procedure for obtaining counsel, as I told you, is vetting your counsel, knowing that these rules exist. And since you don't, nobody told you this. Okay, not to seek or obtain from an unrepresented, not to seek to obtain from an unrepresented accused of a waiver important pre-trial rights, such as the right to a preliminary hearing. A lot of lawyers will bypass that, and that's nothing but more professional procrastination. Okay, if they gave you the availability, the necessity of discovery, nothing would take as long or go as far as it does, especially considering the time involved. You know, that's a whole lot of mental anguish. Make timely disclosure. Disclosure is, discovery. Make timely disclosure to the defense of all evidence or information known to the prosecutor that tends to negate the guilt of the accused or mitigates the offense, and in connection with sentencing, disclose to the defense and to the tribunal all unprivileged mitigating information known to the prosecutor, except when the prosecutor is relieved of this responsibility by a protective order of the tribunal. Okay, I'm just going to go over some key points here. Effect of statements that are necessary to, except for statements that are necessary to inform the public of the nature of the extent the prosecutor's actions and that sever legitimate law enforcement purpose. Excuse me. I really need something to drink. Except for statements that are necessary to inform the public or the nature of the extent of the prosecutor's actions and serve legitimate law enforcement purposes, refrain from extrajudicial comments that pose a serious and imminent threat of heightening public condemnation of the accused, and exercise reasonable care to prevent investigation. They're talking about trial publicity there. They're not supposed to go out there and make public statements on cases they're trying. Okay. To prevent, imminent highlight the public condemnation of the accused, and exercise reasonable care to prevent investigators, law enforcement personnel, employees, or other persons assisting or associated with the prosecutor in a criminal case from making extrajudicial statements that the prosecutor would be prohibited from making under Rule 3.6 of this rule. When a prosecutor knows of new credible, this is the one I was talking about. This is the other case. I have the exonerating evidence that will. It's called exculpatory evidence that will exonerate me. And I tried to get my siblings to just go down there with me so I can give this to the state's attorney. But like I said, we've never had a good relationship. It's more like a frenemy relationship. We're kind of, we smile when we're around each other, but that's about it. When a prosecutor knows of new credible material evidence creating a reasonable likelihood that a convicted defendant did not commit an offense of which the defendant was convicted, the prosecutor shall promptly disclose that evidence to appropriate court or authority. And 2, if the conviction was obtained in the prosecutor's jurisdiction, promptly disclose that evidence to the defendant unless the court authorizes delay, and undertake further reasonable investigation or make reasonable efforts to cause an investigation, determine whether the defendant was convicted of an offense that the defendant did not commit. when the prosecutor knows of clear and convincing evidence establishing that the defendant in the prosecutor's jurisdiction was convicted of an offense that the defendant did not commit, the prosecutor shall seek to remedy the conviction, basically reverse it. Okay, the comment section, which is a good one. The prosecutor has a responsibility of a minister of justice, and not simply that of an advocate. The responsibility carries with it specific obligations to see the defendant is accorded procedural justice, and that guilt is decided upon basis of sufficient evidence. Evidence, people, not hearsay testimony. Okay? So let's get that clear. 1.8, the first sentence of Rule 3.8 restates the established principle in 1924. The Illinois Supreme Court reversed a conviction for murder, and this is what you could use as, as a case citing. The state's attorney in his official capacity is a representative of all people, including the defendant, and it was as much his duty to safeguard, as much as it was his duty to safeguard the constitutional rights of the defendant and those of any other citizen. People versus Cohen, 313, Illinois 508, 526. That was in 1924. So this has been the standard since 1924. Okay, in 1935, the United States Supreme Court described the duty of a federal prosecutor in the following passage. I love this part. The United States Attorney is a representative not of an ordinary party to controversy, but of a sovereignty whose obligation to govern impartiality and is compelling as it is obligation to govern at all, whose interest, therefore, in a criminal prosecution is not that it shall win a case, but that justice shall be done. As such, he is a peculiar, very definite sense of a servant of the law, the twofold aim of which is the guilt shall not escape or innocent suffer. He may prosecute with the earnestness and vigor, indeed he should do so, but while he may strike hard blows, he is not at liberty to strike foul ones. It is much his duty to refrain from improper methods calculated to produce a wrongful conviction as it is to use every legitimate means to bring about a just one. You gotta love that, right? Now that's been the standard since 1935, and that was established by the U.S. Supreme Court. And you see, I mentioned they did not comply. The first sentence of 3.8 is not a set exact standard, but one good prosecutor will readily recognize and have always adhered to in the discharge of their duties. I mentioned about Kim Fox refusing to prosecute cases for no probable cause. No probable cause, the lady's been throwing them out. At least she's honest. All those other attorneys, state's attorneys, they will prosecute anybody and everybody. So I hate attorneys. I don't know that woman. I don't like her, but that's the closest the state of Illinois, Cook County, has come to an honest prosecutor. Specific standards such as those in 3.3, 3.4, 3.5, 3.6, the remaining paragraphs 3.8, and other applicable rules provide guidance for specific situations. Rule 3.8 is intended to remind prosecutors that the touchstone of ethical conduct is the duty to act fairly, honestly, and honorably. In Illinois, a defendant may waive preliminary hearing, and the only reason people do is because the lawyer tells them to. That's ill-advised. And therefore lose a valuable opportunity to challenge probable cause. Accordingly, prosecutors should not seek to obtain waivers of preliminary hearings or other important pre-trial rights from unrepresented accused persons. Paragraph C does not apply, however, to the accused appearing pro se with an approval of the tribunal, nor does it forbid the law questioning of an uncharged suspect who has knowingly waived the rights to counsel and silence. The expectation in paragraph D recognizes the prosecutor may seek an appropriate protective order from tribal if disclosure of information to the defense could result in substantial harm to an individual or to the public interest. Paragraph 4, paragraph E is intended to eliminate insurance of lawyer subpoenas, grand jury. Okay, then here we are again. Rule 3.6 prohibits extrajudicial statements, meaning statements said outside the court that pose a serious and imminent threat of prejudicing I'm sorry, I'm tired. I've been doing this for hours. The judiciary proceeding. In the context of criminal prosecution, a prosecutor's extrajudicial statement can create the additional problem of increasing public condemnation of the accused. Now, you got to remember, the state's attorney is basically said here earlier is in charge of the police. So the police know they got lawyers, that they're not supposed to be out there victim shaming. And they victim shame so that way the cops don't look that bad. People, you got to realize the thin blue line isn't just the police. It's your lawyer. It's the state's attorney. It's all lawyers out there. It's every goddamn judge out there. It's the FBI, the CIA. I mean, all these people are above the law, and you are below it. And the only way you're going to level this playing field out is to do this. Okay. Okay, we're going to scroll down. You could read this yourself. Okay, 7, when a prosecutor knows of new credible material evidence creating a reasonable likelihood that a person outside the prosecutor jurisdiction was convicted of a crime the person did not commit, paragraph G requires prompt disclosure to the court or other appropriate authorities such as chief prosecutor where the conviction occurred. So even though not just a prosecutor, but any lawyer that knows of a wrongful conviction, a failure to report is misconduct. Okay, so there's a rule that says you have to report, and if you don't report, that's misconduct. Isn't that great? You could use that against them, okay? Truthfulness in statements to others, failure to comply. In the course of representing a client, a lawyer shall not knowingly make false statements or material fact or law to a third person. I had my family's lawyer tell them that all this horrible stuff and I was going to go to prison for 30, 40 years or something. So he violated that. In the course of representing a client, a lawyer shall not knowingly make false statements of material fact or law to a third person. And the third person was my mom, my sisters, my dad. B, failure to disclose material fact when disclosure is necessary to avoid assisting a criminal or fraudulent act by a client unless disclosure is prohibited. This is mine. Truthfulness statements to others was non-existent to when reasonable knowledge is lacking. Silence and a lack of disclosure lacks truthfulness in any statements. That's a little thing I threw in there. Which also in comments it says misrepresentation, so that's misrepresentation. Now I remember there's a video I did on the statement of facts, okay, that the state's attorney issues after conviction. That'll determine whether or not you get probation, time, how much time. This rule refers to the statement of facts as well. Whether a particular statement should be regarded as one of fact can depend on circumstances. Under generally accepted conventions and negotiations, certain types of statements orally are not taken as statements of material fact. Estimates the price of value placed on a subject transaction at a party's intentions acceptable to an acceptable settlement or a claim of ordinary in this category, so as in the existence of an undisclosed principal, except where non-disclosure of principal would constitute fraud. Remember I mentioned fraud? Lawyers should be mindful of their obligations under applicable law to avoid criminal and notorious misrepresentation. Crime or fraud by client. A lawyer is prohibited from counseling or assisting a client in the conduct the lawyer knows is criminal or fraudulent. Okay, Rule 4.3, dealing with an unrepresented person, failure to comply. This goes towards when I was arrested. When I cited my Miranda rights, the police sent in the assistant state's attorney. Ruling 4.3, dealing with an unrepresented person, failure to comply. In dealing with in a dealing on behalf of a client with a person who is not represented by counsel, a lawyer shall not state or imply that the lawyer is disinterested. When a lawyer knows or reasonably should know that the unrepresented person misunderstands the lawyer's role in the matter, the lawyer shall make reasonable efforts to correct the misunderstanding. The lawyer shall not give legal advice to an unrepresented person other than advice to secure counsel. If the lawyer knows or reasonably should know that the interests of such person are or have reasonable possibility of being in conflict with the interests of the client. Okay, I added the comments underneath that rule. Responsibility of partners, managers, and supervisory lawyers, failure to comply. A partner in a law firm, a lawyer who individually or together with other lawyers possess process comparable marginal authority in a law firm shall make reasonable efforts to ensure that the firm has in effect measures giving reasonable assurance that lawyers in the firm conform to the rules of professional conduct. And that goes to the state's attorney, because assistant state's attorney once screwed me over, but the state's attorney should be checking out all his stooges to make sure that they abide by the rules of professional conduct. A lawyer having direct supervisory authority over another lawyer shall make reasonable efforts to ensure that other lawyers conform to the rules of professional conduct. A lawyer shall be responsible for another's violation of the rules of professional conduct if the lawyer orders with knowledge of specific conduct ratifies the conduct involved. The lawyer is a partner, has comparable managerial authority in the law firm which other lawyers practice, or has direct supervisory authority over the lawyer and knows of the conduct at the time when its consequences can be avoided or mitigated, but fails to take reasonable remedial action. Okay, people, so like I said, under that, I also added comments, and that's to give you an idea to what the lawyer's supposed to do. This right here will tell you what the lawyer's supposed to do. Okay, so whether a lawyer has supervisory authority in particular circumstances and question of fact, partners and lawyers with comparable authority have at least direct responsibility for all the work being done by that firm. Responsibility of a subordinate lawyer. That goes for the assistant state's attorney. A lawyer is bound by the rules of, a lawyer is bound by the rules of professional conduct, notwithstanding the lawyer acted at the direction of another person. Subordinate lawyer does not violate the rules of professional conduct if the lawyer acts in accordance with the supervisory lawyer's reasonable resolution of arguable question of professional duty. In the comments down here, we'll give you a couple examples. 6.2, accepting appointments. The lawyer shall not seek or seek to avoid appointment by tribunal to represent a person except for good cause. When you cite your lawyer for ineffective assistance of counsel, the judge usually dismisses them and doesn't even press charges against them or files charges with the ARDC. Then they'll tell you have to defend yourself. That's a failure to comply. Because most lawyers, once any lawyer finds out that you asserted ineffective assistance of counsel in a court of law, they will reject or refuse to work for you. That is not good cause. Okay? So just because you know how the game is played, that don't mean they can quit or not work for you. If the judge appoints them, they have to have a good reason not to outside of you, because you know the rules of professional conduct. Okay. Comments down here will tell you about that a little bit. Appointed counsel. That talks to you about the public defender's office. Communications concerning a lawyer's services. Failure to comply. A lawyer shall not make false or misleading communication about a lawyer or lawyer services. My lawyer told me he was old friends with the judge and he could get her to, see his way. A communication is false or misleading if it contains material representation of the fact or omits fact necessary to make that statement considered as a whole, not material misleading. And the comments will tell you this rule governs all communication by the lawyer's services. Okay. Rule 8.3, reporting professional misconduct. I spoke about that earlier. Failure to comply. The judge never enforced the rules of professional conduct, so this is my statement. The judge never enforced the rules of professional conduct, so it's easy to understand the counselors that perpetrated this fraud won't be filing with the Judicial Inquiry Board. I forgot to mention, yet alone filing against each other with the ARDC. So, I put down here, Canon 3, a judge should perform the duties of judicial office impartially and diligently. So let me reiterate, the judge never enforced the rules of professional conduct. So is that being impartial or diligent? A judge having knowledge of violation of these canons or on the part of a judge or violation of Rule 8.4, rules of professional conduct, part of a lawyer shall take or initiate appropriate disciplinary measures. Now, the judge knew nobody was abiding by the rules of professional conduct, so he should have reported them, but he or she didn't. In my case, she didn't. This is the first of complaints to be filed in this manner, so I will rely on you to forward the necessary complaints to the Judicial Inquiry Board. That's my statement. A lawyer who knows another lawyer has committed a violation of Rule 8.4 shall inform appropriate professional authority. A lawyer who knows that a judge has committed a violation of applicable rules of judicial conduct that raises a substantial question to the judge's fitness of office shall inform the appropriate authority. This rule does not require disclosure of information otherwise protected by the attorney-client privilege or by law of information gained by a lawyer or judge while participating in an approved lawyer's assistance program or intermediary program approved by certain courts, which non-disciplinary complaints against judges or lawyers can be referred. A lawyer who has been disciplined as a result of a lawyer disciplinary action brought before anybody other than the Illinois Registration and Disciplinary Commission shall report that to the commission. So if you file a complaint with the ABA or in Illinois, it's the Illinois Bar Association, you have to let these people know you did, the ARDC or your state agency. The comments down here, that'll support everything I'm talking about. All right, I want to keep this under an hour and a half. Rule 8.4, misconduct, failure to comply. It is professional misconduct for a lawyer to violate or attempt to violate the rules of professional conduct, knowingly assist to or induce another to do so, or to do so through acts of another. B, commit a criminal act that reflects adversely on the lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects. Engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. Okay, engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. Engage in conduct that is prejudicial to the administration of justice. State or imply an ability to influence improperly a government agency or official or to achieve results by means that violate the rules of professional conduct or other law. F, knowingly assist a judge or judicial officer in conduct that is in violation of applicable rules of the judicial conduct or other law. Nor shall a lawyer give or lend anything of value to a judge, official, or employee of a tribunal except those gifts, loans that a judge or a member of the judge's family may receive under Rule 65C4 of the Illinois Code of Judicial Conduct. Permissible campaign contributions to judge or candidates for judge office may be made only by check, draft, or other instrument payable or by to the order of the entity that the lawyer reasonably believes to be a political committee supporting such a judge or candidate. Present, participate in presenting, or threaten to present criminal or professional disciplinary charges to obtain advantage in a civil matter. Okay, well, you can, when you do yours, you do all that copy and paste, and just take the time to read after you do it, okay? A lot of good stuff in here you could throw. Okay, so this is my closing statement, okay? So it starts right here, and it works its way down. So that you probably want to use for yourself. You could use word for word, or you can try to critique it if you wish. May I reiterate, failure to comply with the rules of professional conduct is a deliberate denial of due process and only furthers abuse of power. The Fifth Amendment provides that the citizens not be subject to criminal prosecution and punishment without due process. Citizens may not be tried on the same set of facts twice, and that was the third part of the double jeopardy clause. You know, they can't charge you multiple times for the same crime. Okay, citizens may not be tried on the same set of facts twice and are protected from self-incrimination, the right to remain silent. The amendment also establishes the power of eminent domain, ensuring that private property is not seized for public use without just compensation. Clearly, the Sixth Amendment ensures the right to a speedy trial by a jury of one peers to be informed of the crimes with they are charged and to confront the witnesses brought by the government. The amendment also provides the accused the right to compel testimony from witnesses and legal representation. The assertion of a quick and speedy trial starts at the point of arrest in a criminal case or in a civil case at the point of filing and limits that to 120 days, something often taken advantage of, which it said up there earlier, professional procrastination. Preamble, a lawyer's responsibility specifically states, and I quote, this is line 12, the legal profession's relative autonomy carries with it special responsibilities of self-government. The profession has a responsibility to ensure that its regulations are conceived in the public interest and not furtherance of a patriarchal or self-interest concerns of the bar. Every lawyer is responsible for the observance of the rules of professional conduct. A lawyer should also aid in securing their observance by other lawyers. The neglect of these responsibilities compromises the independence of the profession and the public interest which it serves. And line 13 from the preamble, lawyers play a vital role in the preservation of society. The fulfillment of this role requires an understanding by lawyers of the relationship to our legal system. The rules of professional conduct, when properly applied, serve to define that relationship. These rules did not apply if this didn't happen, and I quote, line 2, as a representative of clients, a lawyer performs various functions. This is from the preamble, line 2. The rules did not apply. That's my little part, right? The rules did not apply if this didn't happen, and I quote, line 2 from the preamble, as a representative of clients, lawyer performs various functions. As a lawyer provides the client with informed understanding of the client's legal rights and obligations and explains their practical implications. As a As an advocate, a lawyer zealously asserts the client's position under the rules of the advisory system. As a negotiator, a lawyer seeks a result advantageous to the client but consistent with requirements of honest dealings with others. As an evaluator, a lawyer acts by examining a client's legal affairs and reporting them to the client and to others. Okay, this is me again. The client's rights include requires reasonable knowledge to make an informed decision, and in keeping said requirement from any client is a complete denial of due process. If this conceivably happened to me, which it did, I believe it necessary to see how many others were victims of the perpetrators of the above said fraudulent and frivolous action taken against me. I reiterate that any such violation of the rules of professional conduct is a violation of my right to due process, which would make any case fraudulent and frivolous. This is clearly malicious prosecution, and for what purpose? Financial gain, political aspirations, simple bias and prejudice for statistical purposes, a high rate of conviction, and or a combination of each. Having no knowledge or understanding of what went on in court, not to mention no access to discovery, is not reasonable knowledge. I think that alone proves the denial of due process. Then include the lack of knowledge that the ARDC exists and why. The Eighth Amendment prohibits excessive bail, excessive fines, and cruel and unusual punishment. I believe keeping any client from reasonable knowledge in any shape or form from any legal remedy to obtain justice is a violation of due process. Neglect of these responsibilities compromises the independence of the profession and the public interest in which it serves. I understand there are no laws or rules for criminal action to be taken against the legal system and its entities. For the blatant disregard of due process, you are required to change that. Accountability is required to maintain my trust, the public trust. That is your responsibility, and neglect of these responsibilities compromises the independence of the profession and the public interest which it serves. And having special responsibility for the quality of justice, you are required to zealously assert the public interest which it serves. Demonstrate respect for the legal system and for those you serve, the public. To deny the people, we the people, any single one of us due process can be said to be cruel and unusual punishment. The 10th Amendment assigns all powers not delegated to the United States or prohibited to the states to either the states or to the people. The people require you take action. To defy the rules of professional conduct, the Code of Judicial Conduct is to defy due process, and it is to defy the public trust. A sacred trust and must be dealt with accordingly. Betraying the public trust is seditious and treasonous and should have consequences and repercussions. Prosecution is in order. Betraying the public trust is seditious and treasonous and should have consequences, repercussions. Prosecution is in order. When entrusted with a sacred trust, the trust of we the people, one must be held to higher standard when defying that trust. There is no excuse, there is no defense, for every lawyer is responsible for the observance of the rules of professional conduct, as is every judge responsible for the observance of the Code of Judicial Conduct. Neglect of these responsibilities compromises the independence of the profession and the public interest which it serves. Article 8, Illinois Rules of Professional Conduct. This is in the preamble. A lawyer's responsibilities. A lawyer is a member of the legal profession, is a representative of clients, as the officer of the legal system, and a public citizen having special responsibility for the quality of justice. Thus far, there is a lack of quality which is adverse to justice. As a public citizen, a lawyer shall seek improvement of the law, access to the legal system, the administration of justice, and the quality rendered to the legal profession. As a member of the learned profession, a lawyer should cultivate knowledge of the law beyond its use for clients, employ the knowledge to reform of the law, and to work to strengthen legal education. In addition, a lawyer should further the public's understanding of the confidence in the rule of law, the justice system, because institutions in a constitutional democracy depend on popular participation and support to maintain their authority. Now, this is me again. A lot of that's me up there, too. We, the people, require reform necessary to incarcerate those that once held the public trust. The penalties must be swift and severe and beyond compared to any standards set forth for we, the people. One cannot assert qualified immunity, statute of limitations, non-disclosure agreements, as the preamble requires, line 12, the legal profession's relative autonomy carries with it a special responsibility of self-government. The profession has a responsibility to ensure that its regulations are conceived in the public interest and not in furtherance of the patriarchal self-interest concerns of the bar. Every lawyer is responsible for the observance of the rules of professional conduct. A lawyer should also aid in securing their observance by other lawyers. Neglect of these responsibilities compromises the independence of the profession and the public interest which it serves. To not proceed with criminal prosecution against those that perpetrated fraud in a court of law by defying due process is not in the public interest and is furtherance of a patriarchal and self-interest of the bar. We the people have spoken. The public interest must prevail. No one above the law, lawyers, judges, politicians, police, the president, and no one below the law like me. And when I say me, I mean we, as in we the people. I am many. We are one. We are the defenders of the Constitution. In a nation of laws, we stand by rule of the law and demand you do your duty, stand by your oath, and defend the Constitution as willingly and openly as we do. And then I quoted a few of my favorite people in history. I love history. I can't even, it would take me years to tell you what I absorbed. Okay. So here's a few famous quotes. I came here where freedom is being defended to serve it and live or die for it. General Casimir Pulaski to General George Washington, 1777. Without due process, there is no life, liberty, or the pursuit of happiness. You cannot divide the very principles this great nation was founded upon. We hold these truths to be self-evident that all men are created equal, and they are endowed by the Creator with certain inalienable rights, that among these are life, liberty, and the pursuit of happiness. Thomas Jefferson, the Declaration of Independence, Second Constitutional Congress, Philadelphia, Pennsylvania, 1776. We hold these truths to be self-evident that all men and women are created equal. Elizabeth Cady Stratton, the Declaration of Rights and Sentiments, Women's Right Convention, Seneca Falls, New York, 1848. You're going to love this one. 407 years ago, our fathers brought forth on this continent a new nation, conceived in liberty and dedicated to the proposition that all men are created equal. President Abraham Lincoln, Gettysburg Address, Gettysburg Battlefield, Pennsylvania, 1863. And the OG of dreamers, I have a dream that one day this nation will rise up and live out the true meaning of its creed. We hold these truths to be self-evident that all men are created equal. Reverend Martin Luther King, Jr., March on Washington for Jobs and Freedom, Washington, ARDC 1963. As you see, I signed it, I dated it, I sent it electronically several times, and no answer. And if you go to the ARDC website, it'll tell you they give themselves 2 weeks to reply. Now, with that being said and done, what documentation is needed? Good night, people. God bless and good night.